Yes, Mr. Ikechukwu Ikeji joins us next to give his perspective on the same Taraba Election Petition Tribunal judgments. Thank you for coming on this morning.
Thank you so much, Chamberlain, for having me.
Well, several perspectives have made the rounds, comparing it with different cases, but let's start with getting your interpretation of what that judgment is about.
Well, in my view, I think the law is confused with regards to the effect of nullifying an election. Section 177 provides a list of qualifying elements for a candidate contesting for governorship.
That's what Constitution
of the 1999 Constitution, and one of it is that such a person must be sponsored by a political party. Now, the definition of sponsorship here may have been expanded to include nomination, validly nominated. That is a discussion for another day, whether we should continue to discuss valid nomination within the context of sponsorship. Because if you talk about sponsorship by a political party, I think it's subjective to the political party. I think there should not be an objective view to it. It should be subjective. In other words, it should be the opinion, what the political party says, that this is my candidate, that should be upheld. But that is a discussion for another day. However, if valid nomination can be brought in within the purview of sponsorship by a political party, that means that we are pulling the rug from under the legs of the political party with regards to its right and power to bring out its own candidate.
But it's not an absolute right. It says, yes, you got the right, but you had to comply with the stipulations. I
agree with you. That is why I'm saying it's a discussion for another day. We have arrived at this situation now where valid nomination is being brought in under the principle of sponsorship by the political party. And so the question in the Taraba election was that the governor was not validly nominated. And an issue was raised with regards to the doctrine of wasted votes. I don't think the doctrine of wasted votes is in the Electoral Act. However, where the court, the tribunal finds that the nomination process, the primaries, did not follow the extant laws, the Electoral Act as it were, the Constitution, the Electoral Act makes certain provisions, but that provision has been subject to judicial interpretation. The provision is Section 140, subsection 2, which says that the tribunal shall not declare this candidate with the second highest vote as the duly elected candidate, but shall order for a rerun. However, there was a case in 2010 at the Federal High Court, Abuja, that declared that section, that subsection, as unconstitutional and null and void. Now, that's a situation that up until now we need a clarification on. Because a lot of people have been arguing that section 142 should have been, the tribunal should have averted its mind to it. But there's a case that has declared that section invalid, and there's no challenge to that case. And in point of fact, the Supreme Court, in a more recent case, in February 2015, in JEV against Iyokom, decided that, yes, indeed, that subsection has been duly declared null and void, and therefore remains inoperative, and as a result is good. The declaration by the Federal High Court Abuja is good law, and therefore that section 142 is no longer operative. I think we need to digest that.
So it's as good as not having it in the document.
It's as good as, yes, that is the implication of these decisions. And so the tribunal may have averted its mind to this situation. And
it's a possibility. I mean, if the Supreme Court says so, then that's what it is. That's how lawyers view the rulings of the Supreme Court.
But again, sorry, Mayope, before you go to the next question, I've not ended on that line of thought.
Yeah, before you go to your next line of thought, I just want to ask, I mean, usually when a section goes against the Constitution, that's when it's usually declared null and void. What parts of the Constitution could that...
Section 239 and Section 285. Section 239 grants the tribunal or a court the power to make any declaration whatsoever with regards to who is validly elected. And so if the tribunal decides that by virtue of its findings that the person who came second was validly elected, the Constitution would have, by implication, empowered the tribunal to declare that person as the rightful winner. But the implication of Section 142 would have been to go against that Section 235 and Section 289, so as to remove that power from the court, oust that power from the court to declare the person it thinks validly won the election as having won the election. So that is the premise upon which those decisions said. But I am also saying that the Supreme Court may also not have averted its mind to the amendment to the Electoral Act of 2010, of that section 142. It was amended, and that amendment was dated 31st December 2010. Whereas the decision upon which the Supreme Court said yes, that section has been struck out, was decided in 2010. I am not sure of the date, but whatever date it was, it cannot be later than 31st December 2010. And if after the decision of the court, the National Assembly has also come out again to make an amendment, which also ranks as a law, as an act, I think that it is the latest principle that should be applied, and that latest principle ought to have been that the election ought to have been nullified and a rerun declared. However, irrespective of this position, that the amendment came later than the
Supreme Court,
the Federal High Court decision.